Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we start with another regulation, that is the SER, the Stock Exchange and Clearing Corporation Regulations 2018. So we have already covered all the acts that were mentioned in our security law syllabus, and we have also covered 3 regulations after that, and now this is our 4th regulation, that is the Stock Exchange and Clearing Corporation Regulation of 2018. So I have been stressing on this point again and again that 40% weightage it has been given to the security laws, which forms a very important part of your syllabus. So please be very careful while you are preparing for the security laws. You don't have to leave any act, you don't have to leave any regulation. Please make sure that you are reading all these acts, you are reading all these regulations. So let's begin with our lecture. Before I start, I would like to tell you that EduTap has come up with 2 courses for the phase 2 examination. The first one being the test series. The features of test series, they include firstly chapter wise tests, which means you get different tests for each chapter that has been mentioned in your syllabus, including the criminal laws, including the security laws, including the company laws, right? So for example, that IPC, it has been divided into different chapters, and according to these chapters your tests are also divided. That means you get separate tests for each of such chapter. Then you get full length test with evaluation. So the unique feature here is that you get it with evaluation. Our experts are going to be evaluating your answers, especially the descriptive part that is introduced by SEBI this year, right? So they will be evaluating it for your benefit. They will be evaluating it and will be giving you the necessary feedback. And you also get one-on-one mentor support. The second course is the live crash course. It includes live classes. The live classes, they have already started, and we are covering each and every important topic, including your criminal laws, including company laws, and including the security laws. So everything that is important will be covered in these. So the live classes, they have already begun. So please make sure if you want to enroll in them, you do it as soon as possible. Then the short notes, you also get short notes which will be very helpful for your descriptive part. It will be a huge help for that. And the third feature is the test series. So all the features that I have mentioned of the test series, about the test series, all the features that I have just mentioned about the test series, they are available to you in the live crash course, and you also get one-on-one mentor support. So all of your queries, all of your questions, they will be answered in these live classes. So please make sure that you do enroll in these. They are going to be very beneficial for your examination. We are running a limited time period offer, so if you want to avail these offers, you can refer to the link in the description. Alright, let's start with the lecture now. Question number 1. Which of the following is true? Securities Contract Regulation, Stock Exchange and Clearing Corporation Regulations, they were formulated in the year 2017, or these regulations contain total 52 regulations. So the answer is only 2, that is the second one is correct but the first one is wrong. Obviously we have read this that they were formulated in the year 2018. So Securities Contract Regulation, Stock Exchange and Clearing Corporation Regulations, they were formulated in the year 2018. Question number 2. The application of seeking recognition of the clearing corporation shall be made in which of the specifically framed form for the clearing corporation? So the answer is D, that is form A. Let's read this. Application for recognition, subject to the compliance with the provisions of the Act, rules and these regulations, an application for the recognition as a stock exchange shall be submitted to the board in form A as prescribed under the rule 3 of the rules, and an application for the recognition as clearing corporation, it shall be submitted to the board in again form A as prescribed in the schedule 1 of these regulations. Question number 3. An applicant seeking recognition as a stock exchange shall comply with which of the following conditions? Applicant should have the necessary infrastructure for orderly execution of trade, adequate investors grievances redressal mechanism and arbitration mechanism. The applicant has adequate investor protection fund and investor service fund, adequate infrastructure to list securities for the trading on its platform, or all. So the answer is E, that is all of these they are required. Consideration for the grant of recognition. An applicant seeking recognition as a stock exchange shall, in addition to the conditions as specified in the sub-regulation 1 and 2, comply with the following conditions, namely The applicant has the necessary infrastructure for the orderly execution of trades. The applicant has an online screen-based trading system. The applicant has an online surveillance capability which monitors positions, prices and volumes in real time so as to ensure the market integrity. The applicant has adequate infrastructure to list securities for trades on its platform wherever applicable. The applicant has necessary capability to have a nationwide network of trading members and has adequate facility to admit and regulate its members. The applicant has made necessary arrangements to establish connectivity with the trading members and the clearing corporation. The applicant has adequate investor protection fund and investor service fund. The applicant has adequate investor grievance redressal mechanism and arbitration mechanism to resolve disputes arising out of the trades and its settlements. The applicant has the facility to disseminate information about trades, quantities and codes in real time to at least 2 information vending networks which are accessible to the investors in the country. The applicant has adequate systems capacity supported by a business continuity plan including a disaster recovery site. The applicant has in its employment sufficient number of persons having adequate professional and other relevant experience. The business feasibility plan has been appraised by a reputed agency having expertise in the securities market, and the last one, any other condition as may be specified by board. So all of these conditions, they are to be met with when we are seeking recognition as a stock exchange. So right, all of these they have to be met with. All right, question number 4. The recognition granted to a clearing corporation shall be in which of the following form? So the answer is option B, that is it will be in form B. The board may, after considering the application under regulation 4 and being satisfied that the applicant has complied with the conditions as are laid down in regulation 7 and is eligible to act as a recognized stock exchange or recognized clearing corporation as the case may be, it grant regulation to the applicant in terms of section 4 of the act in the interest of the securities market. So if all these if all the conditions they are met with that we have just read, in that case they will be granted what? They will be granted the recognition. The recognition granted to the stock exchange under sub rule 1 shall be in form B of the rule. The recognition granted to a clearing corporation, it shall also be in form B of schedule 1 of these regulations. The recognized stock exchange and the recognized clearing corporation shall comply with such other conditions, including those which regard to the nature of the securities to be dealt with as may be imposed by the board from time to time. Question number 5. The recognition granted to the clearing corporation is for what period of time? So the answer is D, that is either it is granted permanently or at least 1 year if it is temporary. So let's read this. Period of recognition. The period of recognition granted to a stock exchange, it shall be as per the rule 6 of these rules. The recognition granted to the clearing corporation unless granted on a permanent basis. So either it will be for a permanent basis or it shall be for such period not less than 1 year as may be specified by the board, or if it is not permanent then it cannot be less than 1 year, right? So the recognition granted to a clearing corporation unless granted on a permanent basis shall be for such period which cannot be less than 1 year as may be specified by the board. Question number 6. Consider the following information about withdrawal of recognition of the clearing corporations. Regulation 11 of the Securities Contract Regulations, Securities Exchange and Clearing Corporation Regulations 2018 mention about it. Form C is to be submitted for the withdrawal of the recognition of the clearing corporation. So what actually is the correct answer? That it has been provided where? It has been provided in regulation 13. Regulation granted to the stock exchange or a clearing corporation may be withdrawn in the manner provided under the section 5 of the Act. Question number 7. Guarantee of settlement of trades is the responsibility of who? The answer to this is B, that it is the responsibility of the clearing corporation. So every recognized clearing corporation shall establish and maintain a fund by whatever name called for each segment to guarantee the settlement of the trades executed in respective segments of recognized stock exchange. So it is the duty of who? It is the duty of the clearing corporation as mentioned in the regulation 37. Alright, question number 8. Which of the following can acquire up to 15% of the shareholding in a clearing corporation? So the answer to this is E, that is all of these are correct. Let's read this also. No person resident outside India shall directly or indirectly, either individually or together, with persons acting in concert, acquire or hold more than 5% of the paid up equity shares capitals in recognized clearing corporation, provided that. So the general rule is 5%, but there is a proviso. A foreign stock exchange, foreign depository, foreign banking company, foreign insurance company, foreign commodity derivatives exchange, a bilateral or multilateral financial institution approved by the central government, they may acquire or hold either directly or indirectly, either individually or together with the person acting to concert into 15%. So they can hold how much? They can hold 15% of the paid up equity share capital of a recognized clearing corporation. For the purpose of this proviso, the persons referred to in clause A to F shall mean persons recognized incorporated outside India. Question number 9. The recognized stock exchange and the recognized clearing corporation shall disclose to the board about their shareholding pattern on a quarterly basis. What are included in this information? So the answer is D, that is B and C, the names of the shareholders who have acquired more than 5% of shares in that quarter, and the name of the shareholders who have acquired up to 15% in that quarter. So let's read this. So this is disclosure of shareholding without prejudice to the provisions of the Act, rules and these regulations. The recognized stock exchanges and the recognized clearing corporations shall disclose the board in the format specified by the board their shareholding patterns on a quarterly basis. So it is on the quarterly basis within 15 days from the end of each quarter. So it is 15 days from the end of that quarter, including therein the following. So what all is included? The names of the 10 largest shareholders along with the number and percentage of the shares held by them. So they have to disclose the names of the 10 largest shareholders and the percentage of their shares. The names of the shareholders falling under regulation 17 and 18 who have acquired shares in that quarter. A recognized stock exchange and a recognized clearing corporation shall monitor and ensure compliance with this chapter at all times. Moving on, question number 10. Which statement states truth about the compliance officer? The compliance officer shall independently report to the board any non-compliance of any provision within 10 days. Every recognized stock exchange and recognized clearing corporation shall appoint a compliance officer who shall be responsible for monitoring the compliance of the Act, the Securities and Exchange Board of India Act, rules, regulations or directions issued thereunder, and for the redressal of the investors' grievances. So the answer is option C, that is second part is correct but the first one is not. What is the correct answer? The compliance officer shall immediately, it is immediately, right? So the compliance officer shall immediately and independently report to the board any non-compliance of any provision stated in sub-regulation 1 observed by him. So the correct answer is actually immediately. What was mentioned? It was mentioned in the question, the compliance officer shall independently report to the board any non-compliance of the provision within 10 days. It is not 10 days but it has to be reported immediately. Alright, question number 11. Penalties levied by the recognized stock exchange or recognized clearing corporation shall be credited into which fund? So the answer is B, that is investors protection fund, right? So penalties levied by the recognized stock exchange or recognized clearing corporation shall be credited to its investors protection fund or the fund as is specified in the regulation 37 as the case may be. Question number 12. What directions SEBI can issue in public interest under Securities Contract Regulation, Stock Exchange and Clearing Corporation Regulation 2018? The answer is D, that is all of these directions that are mentioned in the question, they are correct. Let's read this. Debarring a recognized stock exchange or recognized clearing corporation from introducing new products and services and restricting its existing activities, products and services, imposing such monetary penalty as may be determined by the board on the recognized stock exchange or recognized clearing corporation, directors, committee members, key managerial personals, employees or any other persons associated with the recognized stock exchange or recognized clearing corporation, restricting any such person to attend meetings or otherwise participate or involve themselves in the functioning of the recognized stock exchange and the recognized clearing corporation. So all of these, they are actually what? They are correct. So all of these are actually correct. SEBI can issue directions in all of these matters. Alright, question number 14. The combined holding of all the persons resident outside India in the paid up equity share capital of a recognized stock exchange shall not exceed. So the answer is C, 49%, right? They cannot exceed 49%. Subject to the limits as otherwise prescribed by the central government from time to time, the combined holding of all the persons resident outside India in the paid up equity share capital of a recognized stock exchange shall not exceed at any time 49% of its total paid up equity share capital. So it cannot exceed 49% of its total paid up equity share capital. Alright, last question, question number 15. Which of the following is false regarding listing of the securities of stock exchange? So the answer is option D, that is approval of the central government must be taken before the securities of the exchange board are listed. No, it is not the correct answer, but the correct answer is that the approval of the board must be taken, right? Let's read this also. Subject to the provisions of the applicable law in force, a recognized stock exchange may apply for the listing of its securities on any recognized stock exchange other than itself and its associated stock exchange if it is compliant with the provisions of these regulations, particularly those relating to the ownership and governance. It has completed 3 years of continuous trading operations immediately preceding the date of application of listing, and it has obtained approval of the board. So the approval has to be taken from the board, provided the board may specify such conditions as it may deem fit in the interest of the securities market, including those in relation to the transfer of the shares held by any person. A recognized stock exchange shall not list any securities of its associates. The securities of the recognized clearing corporation shall not be listed on any stock exchange. So the securities of the clearing corporation, they cannot be listed on the stock exchange. So right, this was the last question. Now the question for achievers. Which of the following is false regarding the disclosure to be made by people holding acquiring shares in the stock exchange or clearing corporation? If a person wants to more than 5%, then he should seek prior approval of the board. If a person acquires more than 2%, then he should seek approval within 15 days of the acquisition. If a person acquires more than 5%, then he should seek approval within 30 days of the acquisition. A person acquiring shares of the stock exchange or clearing corporation must be fit and proper person except in case of holding is less than 2% of the stock exchange or none of the above. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.